Hello, my name is Lungile Jere. I am a law student at the University of Malawi Chancellor College. I'll be presenting to you a paper titled The COVID-19 Pandemic, an opportunity to strengthen the enforcement of environmental law in Malawi. My presentation is outlined as follows. To begin with, this paper is premised on the various opinions that suggest that the COVID-19 pandemic is a disease of zoonotic origin. Like any other disease of zoonotic origin, it is an indication of the unhealthy relationship between human beings and other animals. In her article on the enforcement of environmental law in Malawi, Makanje states that negative societal attitudes towards environmental protection are some of the causes or some of the barriers to the enforcement of environmental law in Malawi. This paper, in line with Jeremy Bentham's theory of law, suggests that Malawi's experience of the COVID-19 pandemic can be used to educate people on the reason behind the law, therefore giving the law the legitimacy it deserves, as if people understand the rationale behind the law, they are more likely to refrain from conduct or behaviors that are deleterious to the environment. First, a brief background of the Malawian context. Malawi has an estimated population of 18.6 million people, the majority of whom live below the poverty line. It has a very high density, and about 1/3 of the country's economy is dependent on agriculture. These statistics indicate how much pressure the people exert on the environment. People need trees for fuel because they cannot afford electricity. 81% of the population use firewood for fuel. This results into heavy deforestation and also land degradation, both of which result into the depletion of wildlife habitats, thereby increasing the chances of interaction between human beings and wild animals, and also wild animals and domesticated animals, thereby creating the possibility for disease spillovers. This picture is from an article where villagers complained to the government that elephants were eating their crops. However, a traditional authority from the area stated that the animals were eating their crops. The animals had access to their crops because the people had encroached onto land belonging to the game reserve. According to the Ministry of Health, the COVID-19 pandemic has caused 174 deaths of Malawian people. And according to the UNDP, while the COVID-19 pandemic is considered is a health crisis in the short term, in the long term, it is most likely to result into social and economic crisis over time. A survey by the World Bank and the National Statistics Office has indicated that the COVID-19 pandemic may result into an increase in poverty in both rural and urban Malawi, a reduction in revenue for businesses, both rural and urban Malawi. It has also resulted into a reduction in access to basic needs such as healthcare and access to food. And also schools have been closed since March this year, affecting about 6 million students. Further, the survey states that the COVID-19 pandemic has affected employment and livelihood because a lot of businesses and a lot of companies have not been operating at full capacity. The national environmental law in Malawi is provided for in the Constitution, the Environmental Management Act, and sectoral legislation. The Constitution only provides for environmental law as a principle of national policy. The Environmental Management Act of 2017, on the other hand, provides for the right to a clean and healthy environment. It provides for an environmental protection authority. It also provides for locus standi, which Banda 2019 opines that is the most significant reform to the law of standing in environmental law in Malawi, because the section provides that an individual can commence an action to protect the environment without having to show that she or he has suffered a personal loss. The Environmental Management Act also provides for local participation. It provides that projects that are likely to affect the environment should be preceded by environmental and social impact assessments. It provides for environmental protection orders and also sanctions for violations of provisions of the Act. Sector legislation includes the Forestry Act, the National Parks, and the National Parks and Wildlife Act. There's been various successes in the enforcement of environmental law in Malawi. This paper will only mention a few. One of which is the arrest of 2 men that were involved in the trafficking of ivory from Malawi. While the lower court only fined them $5,500, the Supreme Court overruled the lower court decision and sentenced this man to 8 years imprisonment. This was a great win for the enforcement of environmental law in Malawi. Secondly, in 2019, the police arrested 9 individuals that are members of a gang that is involved in the trafficking of wildlife, one of whom is believed to be a kingpin in the international wild trafficking network. Another success story is the case of State and Lungile Board and others ex parte Malawi Law Society. In this case, Malawi Law Society commenced an action to enforce the Environmental Management Act's provision for a requirement rather that projects likely to affect the environment be preceded with environmental impact assessments. However, Maganje opines that there are various problems with the enforcement of environmental law in Malawi. For instance, because the majority of the population is poor, people depend on the environment for sustenance, and therefore they prioritize survival over environmental conservation. Additionally, the enforcement of environmental law in Malawi overemphasizes criminal sanctions. While we have success stories, as already stated earlier, this is problematic because the punishments only punish people for the wrongs after the act. This does not reinforce the environmental principle of prevention. Thirdly, the enforcement of environmental law in Malawi has not been as strong because a lot of people are ignorant about the law, they're ignorant about the rationale behind the law, and they're ignorant about the sustainable use of the environment. This ignorance results into a negative attitude towards environmental protection. One example of an example of where this ignorance of the law and this negative attitude towards environmental protection is depicted is in the case of Republic versus Maria Akimu, where the police tried to arrest a woman who was involved in the trafficking of elephant tusks. However, members of her community attacked the police because they did not believe that trafficking elephant tusks was a moral wrong warranting an arrest. This paper suggests that the country's experience of the COVID-19 pandemic can be used to educate the people on the rationale behind the law, specifically that the law is aimed at preventing adverse effects of environmental degradation, such as the COVID-19 pandemic. This suggestion is premised on Jeremy Bentham's theory of the law, which provides that the law is effective in guiding behavior if it is accessible and useful to the people it seeks to guide. Bentham further states that effective rules are those that maximize pleasure and minimize pain for the greatest number of people. He therefore suggests that laws should entail reason, because reason will help persuade people that the law, the objectives of in this instance environmental law, are ultimately in their interest, and also using the law to punish people that choose not to be persuaded by the objectives of the law, and violators of environmental law should be punished by imposing, they should be punished through pain. For instance, being sentenced to imprisonment or being fined for environmental wrongs. This paper therefore suggests that our negative experience with the pandemic is an opportunity to engage with people and reason with them that it is in our interests not to deplete animal habitats and not to poach animals. One challenge that this paper anticipates is that the country's approach to regulating behavior during this COVID-19 pandemic, as opined by Associate Professor Kadon Kanjete, can be likened to the implementation of Dogg's Law, because the regulations that have been made entail restrictions and instructions and orders that without any guidance on how people should behave during this time. And these restrictions and orders have been viewed as unreasonable by a lot of people. As such, a lot of people are not being compliant with the law. You will find that not many people will be wearing masks, and not many people are staying home. Further, the survey by World Bank and the National Statistics Office has stated that there is a higher degree of perception of COVID-19 as a threat between there's a higher degree of perception of COVID-19 as a threat by the rich than the poor. This may be problematic because the majority of the population is poor. In conclusion, this paper opines that the country's experience of the COVID-19 pandemic can be used to best teach people that the law can be used to best teach people the rationale behind the law, so that in their understanding of the law, they comply with it and give it the legitimacy or the authority that it currently lacks. Further, according to Jeremy Bentham, reason plus law implies legitimacy of the law and therefore compliance. And compliance with law will result into the attainment of the objectives, the environmental objectives that the law seeks to attain, such as sustainable development and effective participation of the people, because they will be more informed, and all of which are in line with the Agenda 21. Thank you so much for listening, and thank you so much to the organizers for creating this opportunity. Thank you. And these are some of the references that I used. Thank you.